Hello, my true crime lovelies. How are you? Happy Friday. You would think with getting a life sentence, you might get your act right fully installed. Not Sarah, not Sarah Boone. She's filed some ridiculous, or as she likes to spell it, ridiculous motions in family court. And we're going to get into it right after I thank my members for their support. All right, without further ado, the very first one, she's filed it with the court, but it's a letter to James Owens, which WTF, Sarah. So it's dated April 19th, which I think was last Saturday. I know, I've been busy. Returning respondents' family law case file immediately is the subject. Mr. Owens, this is now my fourth letter to you concerning the return of my family law case files you are still in possession of, even after my numerous efforts via phone calls, letters, emails, and by my numerous outside resources ongoing 8 months. I wanted to make you aware I have filed for an order to compel. Is that a threat, Sarah? It doesn't sound like a promise. It sounds like a threat. Filed for an order to compel and a request for assistance with the State Bar Association. Definitely a threat, girl. Neither you nor your office currently represent me. And I am once again encouraging you to please return my property of the aforementioned family law files immediately. As you are aware and have been, I am in necessity, wrong word, of these documents and all materials included. Okay, girls, that's Liberty. And all materials included in this file for my active family law case you promised to aid in, but no fruition was ever made after the conclusion of my criminal case. So if she throws in the $10 word, she thinks it helps. It makes it more ridiculous. Ridiculous. Your promises were also made for use of said family law information during, but to no avail. No avail. During what, girl? What are you talking about? During your criminal case? You have no need or use for any of my family law case files now, then, now, or futuristically. Sarah, futuristically is not what you think it is. Futuristically is more of an aesthetic of looking like it belongs in the future. So he has no need for it when he's in a place that looks like it belongs in the future. That doesn't make sense. I'm saying that for your monkeys because I hopefully they'll bring it back to you. So but no fruition. So the whole paragraph doesn't make any sense because the family courts clearly specified there would be no movement in that case until the resolution of her criminal case. So if she's saying family law information during, but to no avail, if that means that she meant during the criminal case, she thought he was going to be doing something, then she's just an idiot because I mean, we all read the document. The judge clearly said, "Get your other stuff resolved, ma'am. Get your life all the way together." I have a very important life-changing pre-trial conference on May 28th, 2025, and am in desperate need of my case files you are refusing to return to me. Girl, first of all, is it life-changing you asking for money uh for alimony when you're being taken care of by the state of Florida? It's not life changing. If the judge says no, denies whatever you're asking for, your life is still going. You're going to still spend the rest of your life in prison, ma'am. None of that is going to change. Please see my need for these in order to properly prepare for and achieve any success in any manner possible. Now, isn't that what she said the last time? Achieve success. You should withdraw all of your requests. Let your son and his father go on with their lives. Let them keep their money, you selfish cow. Okay. Um, did I say that out loud? Which you are fully aware I have been trying to do for over 5 years. This is not going to get one fly. Both the law and American Bar Association recognize that you have a duty not to obstruct any of my efforts to pursue and prosper in this case. See Rule 4-1.16D of the Florida Rules of Professional Conduct, Florida Bar Ethics Opinion 8811, Donahue v. Vaughn, 721 South 2nd District 356. Oh my God, sorry, from 1998. I am hoping you will finally act with consistency and understanding towards your obligations, my rights, and the law by returning my property of these family law case files and all materials included within 10 days of the delivery of this letter to both your home and business address via certified mail. The address to return my case files, and then I didn't take those out, sorry. So she included her address at the prison, the judge's address, and I believe she copied. Hang on, I'm just going to switch out to another page so I don't have this on the screen. Who did she copy? So her Lowell Annex address twice she's put in there, and then to the court, to the judge, LaShonda K. Jackson. So I don't know why she put her address in twice, but okay. So here's what I'm going to say, and let me take this down because I want you to hear me and see me clearly. Flying monkeys and the lovelies. Okay, so first of all, how did he get the files? Like, did he come to Orange County Jail and pick them up and left with those files? Because if he paid his own hard-earned money, none of which he got from you, to get those files, those belong to him. Now, they may have your name on them, but he owns them legally. If he obtained them not from you and got them from the court, right? You can do the same thing. What is stopping? Oh, money. You don't have any money, right? Also, I feel like she's so spiteful. She's threatening the bar, threatening to contact the bar. I gotta calm down. I can tell my voice is getting louder. Sorry. Oh my gosh, she makes my blood boil. Deep breaths. Deep breaths. So what if he's in a case and I don't know how it's going to work with a bar complaint, but like maybe he has to go for hearings and whatever else, and he has some other, like, let's say a death penalty case going on, and she's distracting him with this BS, demanding that it get to her in 10 days from the receipt, and she sent it to his business address and his home address, allegedly. Now, ma'am, I know you and Lana aren't talking. She shared that with us in the chat, but your new flying monkeys, Nicole is slacking on her job because we all know Owens shut down that office. He is no longer renting, leasing, whatever. So if you're sending it there, you probably know by now the certified mail has come back. Or unless someone else sent it, then the flying monkey knows, because I'm not sure how you send certified mail from prison, but I mean, if there's a will, there's a way, right? So she has no regard for his other clients. And then lastly, girl, he worked for you for free and you giving him all this static? Like, no act right whatsoever. Maybe like send a gracious letter if you really want to get, hey, I've sent you a couple of notes. And when she says a couple, we've seen her text message. She probably sent him a note every single day, multiple times a day. And she said for 8 months, she's had other people bothering him with the threats. Christina Pena, girl, don't get yourself involved in Sarah's foolishness. First of all, I know you're young. You don't have any kids, but what she's asking for is wrong. Nicole, You allegedly have a son. We know you don't live in Australia. So if you lied about that, you could have lied about anything. And conveniently, your son's name is the same as Sarah's son, just spelled differently. So you allegedly have a son, a disabled son, no less. And you are advocating for Sarah to take money out of her son's mouth so that she can get zuzus and wham whams in prison where she is there by her own actions. You ought to be ashamed. You don't have any act right either. But anyway, I digress. We're going to go on to this next because then she sent a motion to compel to the court about Owens. Like the court is not a referee. Also, he never filed a notice of appearance, so he was never officially on record as your attorney for this family court. Now, he may have offered to help. Oh, that's what I was going to say. How about a letter like, hey, I know you've been busy and I've been busy too. Perhaps you've overlooked this. I would really appreciate if you could do me a solid and send me copies of what you've acquired of my family case. You know, I'm a little low on funds and I've got other stuff going on. So that would be a huge help to me if you could do me that favor. And trust and believe it is a favor, Sarah. He doesn't have to do anything for you. He already tried your case for free. Have you thanked him for that? And you know, God bless Owens. Maybe he read the letter and he was like, oh, she's got the personality she's got. But me, she would get crickets. Okay, here we go. Motion to compel. Brian C. Boone, petitioner, and Sarah K. Boone responded. Why bring Brian into this? This is how ridiculous it becomes, right? That we're dragging James through the mud and Brian has to be involved, and Brian's lawyer, who is, I'm sure, charging him by the hour. He's got to pay. Brian's got to pay his lawyer to read this foolishness. Like, she just doesn't care about anybody or anything except for herself and her own needs, wants, desires, random thoughts. Okay, girls, that's enough. No fighting. So, motion to compel former defense counsel James S. Owens to surrender respondent's entire family law case file. Comes now. The respondent, Sarah K. Boone, pro se and in necessity and hereby poor wording. Hereby moves this honorable court to issue an order compelling former criminal defense counsel James S. Owens to return to her the entirety of her family law case file in the above styled matter. In support, respondent states as follows. So there you've told it all. He is your former criminal defense counsel. He never put in a notice of appearance on the family court. Therefore, this judge has no jurisdiction over him, right? Like, he didn't come into her court. He didn't enter anything on the record. So as much as, you know, we like to think of judges as almighty, sitting up on the whatever that's called, you know, looking authoritative. Can we see the two over here? Wait a minute. I'm trying to move out of the way, but I just realized you can't see the full screen. These two, Kranick and Judge Johnson, or Jack, is it Jackson? Sorry, the family court judge. She has no jurisdiction over James Owens. He's not on record as a lawyer in her court for your case. So she can't compel him to do anything, dum-dum. But okay, let's go on. All documents contained therein were originally created and compiled by the respondent for almost 5 years, specifically to be utilized as part of her undeniable evidence against the petitioner in this case. So these sound like more than just court records, though. I don't know what she acquired while she was in jail. That would be undeniable evidence. She's created a lot of evidence, like her text messages that she's off her rocker. But anyway, the respondent only temporarily allowed use of these documents by James S. Owens during her now concluded criminal case and in assistance of this family law case with the mutual understanding of the full return when requested. So it's going to be her word against an officer of the court that is what happened, because she has nothing in writing, right? So she's saying it's a mutual understanding. He could be like, I never told her I was giving that back to her. She insisted that I take it, and after multiple times of telling her no, I just went ahead and took it to let the matter rest. James S. Owens, nor his office currently or futuristically, ugh, is his office looking for a new space that looks like it might be in the future, is or will be representing the respondent in any case matter. He does not have any use or need for any of her family law case files. Okay, he might have recycled them. He has no duty to you regarding the family law case, I guess is my point. He never officially signed on as your attorney. You don't have anything in writing. Going through, there's no attorney client privilege established for the family case. Like, ma'am. Respondents' case materials being denied return by James S. Owens include, but are not limited to, irreplaceable notes, documentations, recordings, letters, correspondence. Well, that's on you, sis. Like, honestly, let's just give her the benefit of the doubt, even though she gives it to no one else. What if he did agree to take them? Why didn't she negotiate? Just copy them and bring me back my originals, right? Because he could have them. And what if his house gets flooded? Or what if his office gets flooded? Or what if there's a fire, right? Due to no fault of his own, he could have lost custody and control of these documents. So why didn't you ask for a copy? Why would you give him your only copy? So court filings, motions, notices, responses, orders, all of which were acquired by the respondent by outside resources. Okay, so call those outside resources. Hey girl, can you make copies again? Run that back. All other documents and tangible items related to her family law case. Like what, ma'am? The respondent is scheduled to appear for a pretrial conference on May 28th, 2025. And for such it, oh, I forgot to share you guys again. Hold on one second. La la la. Somebody's gonna fuss at me. I'm human, I forgot. There's other videos if you don't want to put up with me. So, okay. Um, the respondent has made numerous attempts to recover her property from James S. Owens, including multiple direct calls to his personal and business phone numbers. I wonder if his business number even still works. Three written letters mailed to his home and business addresses. A fourth letter will follow this motion informing him of this formal request to the court for the return of respondent's case files. So now you're letting the judge know that you're harassing an officer of the court and you threatened him and involved her into the foolishness. Numerous third-party efforts, including by two durable power of attorneys, professional representatives, have been made via phone calls and emails. Oh, I wonder if that's Christina and Nicole. Why? Because she's planning on getting that money and she's going to need a durable power of attorney to get that money to her, right? Because she only can have $300 in her trust account with the prison. Otherwise, it has to go, anything additional would have to go to an external bank account. Brian would be depositing it in the external bank account. And one of her one of her durable power of attorneys would be managing that. But I would think it would need to be someone local. But again, we don't really know where Nicole is, other than we know she's not in Australia. But Christina is local. Maybe there's another person. I hope it's not one of the people who's recovering addict who would have access to her, what is it, $61,000 that she's hoping for. Inclusion of respondents' other former defense counsel members has also been attempted via phone and emails by all to assist in retrieval of her case files. So she's bothering Mr. Beck, who's in Arizona. Like, why would he have it? She's bothering Tony Henderson, which he's not giving me vibes of, suffering fools. So ma'am, what? I hope she's not bothering his daughter. Anyway, number 7, despite these extensive efforts, James S. Owens has failed to return the respondent's property. She asserts that his withholding of her vital case materials is hindering the ability she has to properly prepare for court, which is an obvious violation of her constitutional rights and under Florida law and bar standards. No, girl, he was doing you a favor. Under Rule 4.1.16D of the Florida Rules of Professional Conduct, a lawyer is required to surrender papers and property to which the client is entitled upon termination of representation. So now she's commingling conduct, right? She is, yes, they would upon termination of representation, but he represented her in the criminal case. Again, there is no record of him representing her in the family law case. So this rule does not apply to her. The Florida Bar Ethics Opinion 8811 affirms that a client's case is their property, even if the attorney has not been paid. Yet he wasn't your attorney in the family law case, though. You just kind of gave it to him asking for a favor. Moreover, in Donahue v. Vaughn, the court recognized that such files must be returned upon request. The respondent, therefore, is lawfully entitled to immediate return of all materials in her family law file. As such, respondent is legally entitled to her own property and requests the immediate return of the full file in its entirety. I mean, I'm sure the James doesn't need all this headache, so maybe he will just send it to her to get her out of his hair. But if he's mad enough, he might just be like, "Go ahead, girl, try me. Like, run up." Okay, wherefore, pro se respondent Sarah K. Boone respectfully requests from this honorable court to enter an order compelling James S. Owens to 1. Surrender the complete family law case file and all related documents back to her immediately. Package said files clearly marked legal mail and send to Sarah K. Boone. Grant any further relief deemed just and proper. Like, money, girl, what other relief do you need? Respectfully submitted this 19th day of January, and then she has her address and then a certificate of service. She sends it to Brian's attorney, like Brian needs to pay to read through this bullshit, and then to the business address where he no longer conducts business, and his home address. Ma'am, you are so far out of line. Oh, but she's not done. She, just in case we thought, well, maybe she has a little Ackrite installed by now. Oh, no. Here we have a motion for appointment of counsel by the court for respondent Sarah K. Boone. Comes now the respondent, Sarah K. Boone, an indigent and incarcerated individual, broke and in prison, currently housed at Lowell Correctional Institute. She's at the annex now, so I'm not sure why she just put CI. What was the date? She moved to the annex on the 4th. So does she not know where she lives? Respectfully moves this honorable court for the appointment of legal counsel in the above captioned matter. Where they do that? They giving out legal counsel for family law for people who are asking for things that are not even appropriate. In support of this motion, respondent states as follows. Respondent is currently incarcerated at Lowell Correctional Institution and lacks the financial means to retain private counsel for her ongoing family law case, which threatens her co-parenting rights. I have a hard time believing she's still asking for co-parenting rights. I mean, anybody else? You're going to co-parent while you're doing life in prison? Respondent has requested multiple times for mediation, liar, with the petitioner, which the court originally initiated as an alternative to trial. Respondent respectfully continues to request the court to reconsider and grant mediation. So I think she forgot, or maybe she's hoping the judge doesn't see it, that she filed a letter with the court, not agreeing to mediation, but asking a bunch of questions and refusing to set a date because she had cancer and couldn't plan ahead. Like, obviously, if you have a medical appointment, you can cancel it, but she refused to even set a date or give options for dates. And she wanted all of her questions answered before she could even think about it. It was ridiculous. Anyway, Respondent has made extensive efforts to obtain legal representation, contacting over 24 private attorneys requesting their professional assistance, all of whom have declined her case for reasons including her 1, financial circumstances, 2, incarcerated status, and 3, case status. Yeah, you don't have any money. You're in prison asking for co-parenting, and your case, it clearly said, we'll take this up once your criminal case is resolved. As in, if you are found guilty, you get nothing. Nathan, nada. D. Respondent has also contacted nonprofit organizations, including Legal Aid Society of the Orange County Bar Association and Florida Institutional Legal Service, FILS, project with no success. E. Respondent is indigent, as demonstrated by her incarcerated status and her inability to secure private counsel due to the court granting petitioner a continuance on the contempt of court charge made by the respondent. So, wait. First of all, how is the indigent and the contempt of court all in one? So, as demonstrated by her incarcerated status and her inability to secure private counsel due to the court granting petitioner a continuance on the contempt of court charge made by the respondent. So, yes, because what was it? I can't remember. Something v something, but he can't be held in contempt until his motion for either to eliminate or to reduce alimony and child support. Well, the child support they did put a stay on until afterwards, but the um alimony, they said they would decide after they would hear his motion after the resolution of her criminal case. So she's kind of backhanded, like, well, the court gave him a continuance even though he's in contempt. That's why I don't have any money. Yeah, the court was following the law. He could not be held in contempt until his motion was heard. So he did not have to pay you, ma'am. Appointed professional legal counsel is necessary for effective discovery for respondent. What discovery, girl? You're in prison. Respondent has no access to her family law case files, called the clerk, ring ring, which are being held by her criminal attorney despite multiple requests via telephone, email, and USPS for their return. That is the United States Postal Service for those non-US folks that watch. I know we have everybody from around the world. For their return, nor does she have computer access to view files online. Access to these files, which include multiple motions, correspondence to the court, and notices filed by opposing counsel, is vital for the respondent's due process. Girl, if you don't go back and watch the 3-part series, Boone v. Boone, I have it all there for you. I have it all there. Do you want me to write the judge and let her know? B. Respondent has been repeatedly excluded by the petitioner and opposing counsel in all copies, notifications, filings, and correspondence to the court, which has kept her at an incredible disadvantage, denying her right to be kept informed of progress as the respondent in her case to properly prepare and defend herself. Respondent has provided her updated address information to all parties on more than one occasion, being filed online, including during the case management conference on March 26, 2025. Well, Sarah, that might mean something, except on April 4th, you moved. So the address you gave them on March 26 is no longer valid. You also moved. Actually, let's not talk about it. Let's look at it and see, shall we? Here we go. When did Sarah move? 12/30/2024. You moved from Orange County to the Women's Reception Center. Then 1/31, you moved from the Women's Reception Center to Lowell, I guess, correctional institution. 2/6, you're still at Lowell. 2/27, you're still at CI Correctional Institution. Then on 4/4, you move to Lowell Annex. So whatever you gave them on 3/25 is not going to be the same address. Yes, I have paid for her latest files. We're going to go over that in another video. Whew, I have to say, these videos are kind of kicking my pregnant butt, but we're going to get through as many as we can. I got to eat and maybe lay down, but we'll get through it. Okay, so back to where we were in this motion to compel. So yeah, so whatever you sent them on March 26th is not the correct address. Due to the legal complexity of the case and the potential consequences to her parental rights, which are extremely valuable and important to the respondent in all efforts, respondent is unable to adequately and fairly fully represent herself without professional legal counsel. That is, I will say, my mother taught me young, life is not fair. Sarah is always looking for fairly. Not even like fair across the board. It's the entitled fair of like, I should have what I want because I said so. Who else is getting legal, like paid for legal counsel in family court? How is that fair for you to get it and no one else to get it? Like, make it make sense, girl. Indigent respondent has no physical means to equally prepare for trial. Here she goes again, equally fairly. Indigent respondent has no ability to pay for or receive FOIA requested documentation, which contains over 5 years of records, including recorded OCCD and DOC telephone calls and hundreds of tablet messages. I guess one of her friends could, instead of sending her soup money, they could send her, and coffee packages they could go down there and pay for, at least for the tablet messages, because we know the district attorney or the state attorney's office has that. I don't know about these phone calls. Are there phone calls available in FOIA, y'all? Oh my God, that's another rabbit hole I'm gonna have to go down, because we got to hear those. If so, I should just send a note then to the state attorney's office. Oh, I don't have a pen. Okay, anyway, the respondent's necessary and vital evidence against the petitioner are these recorded phone calls. With no ability to pay for or transcribe these recordings, respondent will be denied access to crucial evidence, which heavily impairs her due process. FOIA requests are complicated. No, they're not. And respondent is requesting hundreds of pages of documentation, which she has no means to afford. Costs include search fees, $10 to $50 per hour, depending on the level of staff involved. Photocopying approximately 10 cents per page, and shipping fees. So this is from her Flying Monkeys then. If you go down there are no shipping fees, right? So whoever heard, what do we say, durable power of attorney, whoever they are, trot on down to the Orange County Clerk's office. What are they? They don't have to search for anything. You can look on the docket and give the date and title, and the searching is done. And 10 cents a page. I mean, maybe narrow it down, maybe like narrow the scope to the actual essential things that you need and start there. But I don't know what you think it's going to show in these phone calls. Like, it doesn't matter what Brian said. You are incarcerated. You are in the care, custody, and control of well, first it was the jail, and then now it's the prison of the state of Florida. So what's on the phone call that changes that? In the respondent's continued efforts to be prepared to the best of her limited abilities for the pretrial conference on May 28th, and after expeditiously sending her request for records to the Orange County Corrections Department, a response has been received as follows to convey and confirm respondent's need for professional legal counsel to be appointed to assist in obtaining her necessary effective discovery and evidence, which lawfully allows an equal level of preparation of her defense against petitioner. Good afternoon. A warrant will be required to obtain any documentation of inmate electronic messaging per our legal department. Also, well, we know she ain't getting a warrant. Also, inmate phone calls are not considered public records as the recordings are not material prepared in connection with official agency business, which is intended to perpetuate, communicate, or formalize knowledge. In other words, stop being nosy, y'all. Furthermore, the calls themselves are not a public record pursuant to Bent v. State of Florida. Natasha Fisher, MPA, CCS, Orange County Corrections Department, Risk Management Analyst, Public Records Request Custodian. Well, go on, Natasha. I have talked to Natasha. She's very nice, by the way. Respondent's FOIA request was denied due to a warrant being required to receive her information-rich evidence against petitioner, which appointed legal counsel would have the ability to obtain for her. So I don't know if she realizes this, and maybe I shouldn't say it, but I'm going to say it anyway. If she obtains that and enters it into evidence as discovery, it does become public, and then we can request it. Even though it's in the family law case, I believe. I mean, I have access to her family law records. It's definitely at risk if it's not guaranteed. I guess she could file them under seal, maybe. I just want to know what she thinks is on there. Like, she didn't give any description. She just says it's like rich, evidence rich or whatever. But like, wouldn't you give examples of what you're expecting to find? And do family law judges enter warrants? I mean, I guess they could. I've seen, yeah, they do. I've seen it on some of the court cases. But yeah, I just like, what's the evidence, ma'am? These same electronic messages have been monetarily obtained and published by numerous social media websites and YouTube channels for thousands of dollars, which the respondent is indigent and does not have the means for payment. Not for thousands of dollars, girl. Nobody is spending thousands of dollars on you. Printing basic case files alone calculate a cost of over $414 from the clerk's office, $1 per page, $2 for certification by the clerk, and prepayment must be received before processing can even begin for over 400 pages of respondent's family law case documents. So they would be $2 because in order to enter them into evidence, she would need certified copies, if that's what she's trying to do. But girl, you can look at them for free on my channel, so you just won't be able to enter them into evidence. Respondent is restricted from receiving any and all of her case-defining evidence from outside personal resources. The respondent must solely rely on her limited outside personal resources due to the inaccessibility and unavailability of in-house DOC resources for her personal use to aid her in the gathering of her pertinent case evidence. I don't know what the in-house resources are. Certainly there's got to be other inmates going through family court stuff, right? I mean, mainly those who aren't serving life. But due to the respondent's incarceration status and security protocols of DOC, Department of Corrections, if anybody's wondering, she has no ability to receive any paperwork of any kind except from the court system directly or an attorney on record. So Owens is not an attorney on record, so I don't know how you're trying to get things for him. He's done with your criminal case. He never signed on to your family law case, but yet you're harassing him while understanding that that is not possible because you just typed it. An attorney on record. Good afternoon. All legal mail must be sent in through legal mail to inmates and only from an attorney or the courts directly. The state of an inmate's legal material is in the storage of an inmate's legal materials is in property. If voluminous, must be approved by the assistant warden and the sergeants of the property department or in their single locker. Ruth Ann Foss, DOC classifications officer, incentivized program. So she's taking an excerpt of a response. We don't know what her request was, but it sounds like she asked about storage. But it also is legal mail to inmates only from an attorney. They can send the mail through a tablet like they're sending anything else. It just won't be classified as legal mail, so everybody else can see it. But girl, they can see it on my channel, so just have them send it. The respondent's case-defining legal documents and evidence, like she's beating that dead horse, are unattainable due to all she has collected being in receipt of her outside personal resources. This heavily impedes the respondent's right to prepare sufficiently for this case. The respondent has no means to store her case files and evidence in her DOC issued single drawer. What does that have to do with the judge? What does it have to do with the judge? That sounds like something you need to discuss with the DOC. But didn't they say it could go in another place? Yeah, it can go in property or in their single locker. So you already have your answer. Why are you bothered? You think the judge went to law school, ran for judge, practiced law for all those years to deal with you and your paperwork? That has nothing to do with her? Okay, with professional legal counsel appointed to the respondent to receive and store her evidence, to acquire directly and foremost, she would have the equal ability to defend herself lawfully and appropriately against the petitioner. That sentence says 1,000 words. Against why word it that way? Just to represent herself to the fullest would have been better. Okay. Legal basis for appointment of counsel. A, under Florida law, while there is no absolute right to appointed counsel in civil cases, hallelujah, so she does know, courts have discretion to appoint counsel in cases involving fundamental rights, including parental rights. Recognizing the fundamental nature of parental rights and the necessity of legal representation in proceedings affecting them. The Florida Supreme Court has held that where fundamental liberty interests are at stake, due process may require the appointment of counsel. Federal case law further supports that parental rights are constitutionally protected under the 14th Amendment, and courts must ensure due process protections when those rights are threatened. See Troxel v. Granville. So why did we go to federal law? I mean, federal law is great, but it doesn't override state law. The states are sovereign unto themselves. Under Florida Statute 57081, an indigent litigant may proceed without paying court costs and fees, which supports the broader principle that indigent individuals should not be denied access to justice due to financial constraints. Somebody, I'm not going to look it up, but is that for all cases? Because it seems like maybe that would have been a better way to write the letter to the judge, like asking for asking for a fee waiver for the court costs, because that seems pretty straightforward in a civil case, right? Instead of all of this other BS that she's got in here. It doesn't get her phone calls, but again, what proof is in the phone calls? Okay, the Florida courts have also appointed counsel in family law cases involving incarcerated litigants where representation was necessary for due process. See Trial v. Trial. Holding that a trial court must consider appointing counsel when an incarcerated parent's parental rights are at stake and a lack of representation could result in an unjust outcome. I will give her credit though, at least throughout this, her theme is parental rights and not that damn alimony. So maybe the judge, although it's so chock full of entitlement, like you owe me, I deserve this. This is what's fair. It should be equal. It makes it hard to want to help her. It makes it hard to extend grace to her. Like why that doesn't register with her, I will never know. And why the monkeys don't go, listen, girl, let's get that act right installed. I'll never know. Request for relief. Given the nature of this case, with the importance of the respondent's parental rights, her livelihood futuristically. Girl, you are spending the rest of your life in a Florida prison. I know you think you have an appeal. I mean, you do have an appeal. I know you think you have a shot at winning an appeal. Wah, wah, wah. Wait, I need a sound effect because, I mean, ma'am, what? Surprise, surprise, surprise. You don't have a livelihood futuristically, unless again we're talking about in a pretend world that looks like it comes from the future, and there's like maybe a little Lego Sarah in there, and that is your livelihood you're talking about, but not like for real, not in real life. You're gonna have that because why do you need money if the state of Florida is taking care of you? That's all I want to know. Okay. So because she's kind of back ending into the alimony without being heavy handed, which I kind of like that nuance for her. I mean, it's a step in the right direction, a very, very tiny step, but I mean, I'm going to give credit where credit is due. Okay. Where were we? Her livelihood futuristically and her inability to legally represent herself in full capacity due to her incarceration and indigency. The appointment of professional legal counsel is warranted in the interest of justice and due process. Wherefore, respondent Sarah K. Boone respectfully requests from this honorable court one, entering an order appointing professional legal counsel by the court to assist in acquiring respondent's effective discovery and to rightfully represent her in this family law case and matter. So you think a counsel is going to issue a warrant for you for these calls? They're going to need a little more information. 2, grant any other relief deemed just and proper under her present and uncontrollable circumstances. Oh no, they were controllable, ma'am. You could have unzipped that man. You could have let George out, Mr. George Torres Jr. That was controllable. It was you were the only one in control. It was 100% controllable. I wonder if the family court, I mean, I'm sure she can look it up, what exactly Sarah is in prison for and how cruel it was and how she has showed zero contrition to date. And then it's just her address. She served again the attorney of Brian. For what reason? I don't know. I mean, I guess she has to technically because she's sending it to the judge, but why is she sending it to the judge? I don't even think she knows. I really don't. Like, I think she's just like, well, let's just throw some spaghetti up. It might stick. Let me know. Let me know. But she is trying to make it rain. Make it rain, make it rain, make it rain. It's not going to happen. And when she finds out, maybe she'll say, I have to make myself laugh, so I don't want to like go choke her out. I don't believe in violence. I'm not going to do that. But she does make me so angry. Her poor son. Goodness gracious. He doesn't, I mean, and her lack of restraint, right, shows like she doesn't have good impulse control, which is not good for parenting. And she also has just like thought diarrhea. Any thought that comes into her head, bleh, it's coming out the other end. You know, it's just like, maybe we should say thought vomit. It just is like, what planet is she on? She's on the same planet that Lori Valadebo is. It's all about them. They're going to gaslight us. They're going to do whatever they need to do to get what they want. Whether it makes sense or not, it makes sense to them. And damn it, you are going to figure it out. Or will we? How's that prison life, ladies? How's that working out for you? Let me know what you think. Like, oh my, balls of a burglar just continues. How do we help her get her act right installed? Is that up to us? We're going to move on from her soon. But next month in May, we're going to have this pretrial conference and see how it goes. But justice for Brian and her son at this point. We got justice for George, but set him free. Free, free, set him free, set him free, 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 set him free. I got the sillies. I'm hungry. I'm tired. I'm frustrated with Sarah. Let me know how you doing. Toodles. Talk to you in the comments.